Great. Thanks everybody for joining us today. Look forward to speaking with you about the COVID evolution of purchase agreements and where are we now with my partner, Melissa Kalka. Let's go ahead and kind of get into the slides a little bit. I'm going to click through here. So in terms of agenda, we'll spend a couple minutes on an overview of our firm, and then we'll spend about half of our time on an overview of the purchase agreement, traditionally in the private target context. And then we'll spend the other half of our time on how COVID has impacted transaction agreements, as well as a few brief takeaways about where are we now, as well as Q&A. In terms of Kirkland and Ellis overview, we won't spend too much time here. These are totally promotional slides about how great our firm is. Just a couple of call outs for you. We are one of the world's leading law firms. We have 2,900 lawyers practicing around the world, including 17 offices in the United States. In Texas, we have been here since 2014, starting in Houston. We opened our Dallas office in 2018. We celebrated our third anniversary a couple of months ago. We are up to about 90 attorneys currently, and with our new first-year associate class starting next week, we will eclipse 100 attorneys. We're very proud of our growth in Dallas and the long-term commitment to the Dallas market. And we just opened up in Austin in May of this year. And so we're one of the few non-Texas-based law firms that has 3 offices in Texas, and that takes us to over 300 attorneys practicing in Texas. One more slide on our firm. We're very proud of being a tier 1 firm, really across all the major practice areas. In terms of M&A and private equity, we rank first globally in the United States, as well as in Texas, and have for some time. That deal experience allows us to keep unmatched market knowledge at our fingertips. We have a proprietary database of deal terms from Kirkland and Ellis led deals of more than 2,000 private target M&A transactions. Since we started keeping track of this in 2008, it is incredibly useful to our clients in terms of getting them the best deal terms possible. And just one more tidbit related to just overall share of the market. Our firm handled approximately 22% of all HSR filings in the United States last year. Again, that just goes to our market knowledge and breadth of experience, which we put to work for our clients. So that's it on Kirkland and Ellis. We're going to move into the actual substance of the presentation, starting with the purchase agreement. And so we appreciate that many of you in your practice, look at purchase and sale agreements pretty frequently. We appreciate that some of you may not look at them as frequently. So as noted, we wanted to spend, a fair bit of time hitting what we think are the traditional provisions in a purchase and sale agreement, and just setting the table so that when we speak to how COVID has impacted purchase and sale agreements, we'll all be working from the same, fundamental base of knowledge. And so a purchase agreement traditionally contains the following provisions on the slide that you see set out in front of you, but it would be the purchase and sale mechanics, which in a public deal is going to be basically equity consideration per share, but in a private deal is going to be, an enterprise value with adjustments, and we'll talk about that more in a minute. All deals will have the bulk of these other provisions, but there will be representations and warranties or reps and warranties made by each party to the other in connection with the deal. There will be disclosure schedules, which effectively act as exceptions to those reps and warranties, and also are just general disclosures in connection with the deal. There are pre-closing covenants, which apply in deals that have a period between signing and closing. Conditions to closing, which must be satisfied prior to closing being required of the parties. Again, in a deal that has a period between signing and closing, these are more important. In a deal that is a simultaneous signing and closing, these are more, informative in a roadmap. Termination provisions, again, applicable to a deal with a signing and a subsequent closing that allow the parties to terminate the deal and walk away in certain circumstances with certain remedies. Indemnification, which deals with traditionally a post-closing recourse for breaches of a party's reps and warranties or covenants or certain other specific indemnities that might be negotiated. Again, there's a discrepancy here between a public and a private target deal. Public deals tend to have no post-closing indemnity because the owners of the target business are disaggregated and basically have disappeared after closing, whereas in a private target deal, there's usually somebody to go after, somebody to have recourse against. And then there are post-closing covenants and certain other miscellaneous and boilerplate provisions. So we're going to talk about each of these in a little bit more detail. And again, we are just setting the table here for more specific COVID development section that Melissa will be leading shortly. So we touched on this briefly already, but purchase agreements can be either a concurrent or simultaneous signing and closing, or a bifurcated or subsequent or separate signing and closing. And there's a few different things that go into this. Generally, if a deal is of large enough size that it exceeds the HSR or Hart-Scott-Rodino threshold of $92 million currently, and that gets adjusted annually for inflation and other items, then generally speaking, you will need a separate signing and closing. The one exception would be if the parties decide to file HSR off of a letter of intent and the HSR approval has come in prior to the date that the parties are ready to close. There are other reasons why you might require a separate signing and closing, third-party consents, et cetera. Maybe debt financing. There's various things that can come up on any given deal that might necessitate a separate signing and closing. But many parties, if you're under that deal threshold, or if you can file HSR off of LOI and get your ducks in a row before you're ready to actually sign and close, many parties do prefer the simplicity of a simultaneous signing and closing, in part because there's less to negotiate, including, generally speaking, no termination provisions and no interim operating covenants. In a separate signing and closing, to be clear, you would sign the purchase agreement and you would close later. Signing is when the parties sign the agreements. Closing is really when the equity or the assets is handed over to the buyer, and the risk of loss and possession goes to the buyer. And in exchange, the buyer would pay to the seller the consideration, which would be cash or equity or something along those lines. It could be a vendor note or something like that. The separate signing and closing, as noted, provides the parties time to obtain third-party and government consents, namely HSR, but it could also be certain other consents, including third-party contract consents that are material to operating the business after closing. That gives the parties time to negotiate and finalize ancillary documents, whether that's employment agreements, transition services agreements, or otherwise. Generally, parties like to attach the form at signing and then effectively, update the form for the date and party names and maybe other minor changes at closing. But if timing is a rush to get to signing, and if the parties are amenable, it is not that uncommon to spend the time between signing and closing negotiating and finalizing certain somewhat material ancillary documents. A separate signing and closing requires pre-closing covenants and termination provisions. We'll talk about these in more detail in a little bit, but traditionally pre-closing covenants include a number of provisions called interim operating covenants, which do a couple things, but most importantly, they allow the buyer to feel confident that the business it's buying at closing is the same business that it entered into to buy at signing, and that the business is not changed meaningfully due to actions taken by the seller between signing and closing. And then there would be, of course, closing conditions, which are generally pretty common, and then there can be specific negotiated closing conditions unique to the business. On the right side of the page, simultaneous sign and close, as noted, it means you sign and you close at the same time. So the parties are signing and releasing signature pages, handing over the equity or the assets, as well as paying the consideration, whether it's cash or equity or otherwise, all at the same time, all on the same day. There can be some timing issues. There can be some confidentiality issues and related issues involved with obtaining third-party consents in a sign and close deal. You can imagine the chicken and egg issue when you're trying to give notice to a third party that a deal is expected to happen, but the deal has not yet been signed. And so you're trying to get that party's consent to a deal that is not actually binding on the parties yet, but you need that consent in hand before you're ready to close. that might be something that necessitates a signing and then closing, but many parties, due to the simplicity of a simultaneous sign and close, do choose to deal with that issue of obtaining a third-party consent that is material even prior to signing and closing on a simultaneous basis. Similarly, you'll note that there's no need for pre-closing covenants or termination provisions, and to the extent there are closing conditions in a simultaneous sign and close, that they are effectively not applicable or not really binding. They're more of a roadmap and illustrative in nature, from the perspective that the parties just won't sign if they're not ready to close. So going to the next slide, we're going to spend a little bit of time on the actual purchase and sale mechanics and purchase price components here. Again, this is in the context of a private target M&A transaction, and this applies for your small deal that might be sub 100 million all the way up to your multi-billion-dollar type private target deal. But the general overview would be that there is a base purchase price, and you will take that base purchase price and you will have certain pluses and minuses or certain adds and deducts based on various well-accepted purchase price adjustments. Those include working capital, cash, debt, and transaction expenses. And traditionally, what you will do is you will take those various purchase price adjustments, you will estimate them as of closing, and usually there are mechanics dealing with who presents the estimate and whether the other party has the right to object to the estimate or whether the estimate is accepted as true for purposes of closing. And then there would be a post-closing adjustment or true up to the various purchase price adjustments once the actual numbers are known as of closing, which by definition would have to happen, 60 to 90 days later generally, but some period of time after closing later. And just to take a big step back and give a little background as to why these adjustments make sense, I think most people here with a business background know that you have a business with an equity value and an enterprise value. And the main difference between the equity value and the enterprise value is equity value plus net debt. So debt less cash is enterprise value. And so generally speaking, business parties agree to value a business based on an enterprise value, but they expect that will be debt-free, cash-free in nature, which really gets you back to an equity value construct. And so when a party is buying a business, they really want to pay extra for the cash on hand, and they want to enjoy the benefit of a deduct to value for any debt that they are assuming. And so on the cash and the debt terms, a couple things come to mind. For cash, yes, that the buyer needs to pay dollar for cash on the balance sheet, but many buyers are interested in managing how much equity they need to draw down for a given closing for the funds flow. And so they will require the seller to sweep a certain amount of cash, perhaps it's all cash in excess of a certain threshold, or put a cap on how much cash the buyer will pay for, which creates an incentive for the seller to sweep the cash in excess of that amount. And that's really all around managing how big the check size is the buyer's writing, understanding that economically speaking, the buyer should be paying for all cash on the balance sheet. And then for debt, debt can really be thought of in two different ways. The main part of debt that should really be covered in all purchase agreements is indebtedness for borrowed money, which is also called funded indebtedness to many outside lawyers. And that is true money that is owed to a third party and that will ultimately need to be paid at some point in time. In addition, there are many debt-like items which could include change of control bonuses, retention bonuses, deferred payroll taxes, things like that, that buyers will often negotiate to be included in the debt definition so that to the extent those items remain as liabilities post-closing, they're getting the benefit of a deduct in value or purchase price, as opposed to leaving that to just a rep and warranty that they negotiate for, which would be in turn subject to certain limitations like a deductible, a cap, survival periods, things like that. That covers cash and debt. Transaction expenses are applicable where the company is actually the obligor or the bearer of transaction expenses associated with the deal. The idea is that if the buyer is buying the business, the equity of the business, and inheriting a liability, a transaction expense liability, for example, a fee payable to counsel, a fee payable to an investment banker, a fee payable to a finder, and those amounts have not been paid off as of closing, which would be the measurement time, then that would act as an additional deduct, and the buyer will ensure that those get paid off, subject to delivery of payoff letters in connection with the closing process. It's really just intended to be value neutral to the buyer and the seller, but it is a mechanic that's important to have. And then, kind of saving the most complicated one, but in many ways the easiest one for last. First point, working capital. When a buyer buys a business that is a going concern, in addition to paying for cash and getting a value, offset for debt and transaction expenses, the buyer's expecting that business to have a certain level of normal working capital. Working capital is an accounting term that basically means, and it's really called net working capital, but it really means current assets or assets over the next 12 months, reduced by current liabilities, which are liabilities owed over the next 12 months. It's set forth on a balance sheet. The parties will negotiate what the working capital items are that are applicable to the business, usually making normalizing adjustments, taking out non-recurring items, taking out certain noise from the transaction process, things like that. It's a real value point for buyers and sellers. But at the end of the day, the idea is that the buyer should be paying for normal target level net working capital in the business. And so the parties will negotiate a target working capital number, which is a fixed dollar amount that they have decided, between the two of them, buyer and seller, is the proper amount of working capital for the business that it should have as of closing. Different financial methodologies for that. And just like these other items, that will be estimated as of closing and then trued up post-closing, ultimately resulting in the final purchase price paid. A couple other call outs here that I think we alluded to, but net working capital has targets and collars sometimes. Generally speaking, there is a target, so it's something separate from zero, which again would be the normal level of working capital. Some parties decide that collars make sense, which generally would mean that there is a ceiling on the amount of working capital can swing, up or down, which again gives the parties some certainty over what the max variation could be with respect to working capital. For cash, as mentioned, parties sometimes will negotiate for a sweep or put a cap on how much cash will actually need to be paid for to create the incentive to sweep. Separately, parties usually negotiate for a definition of cash that does not include restricted cash, meaning the buyer would not be paying dollar for dollar for cash that is really reserved for other obligations of the business, for example, offsetting a letter of credit or a surety or something like that. And so these are all negotiated points. Last point is the last bullet here, other components. And Melissa will talk about this in detail. But generally speaking, parties, especially on smaller deals, kind of sub 500 million, sub 300 million, often try to bridge value with an earnout, which is basically where the buyer will agree to pay more money to the seller after closing in connection with performance of the business if it exceeds certain targets that the parties set out. Separately, rollovers allow the parties to bridge a funding gap and also create incentives for the sellers to remain in the business, usually in a minority role with a passive governance structure. After closing, it can create good incentives to continue to grow the business. It can provide additional equity funding. And last but not least, it can solve a funding gap where a buyer may not have sufficient capital to pull off the deal. So the next slide, I think we can cover pretty quickly. I think everybody here is generally familiar with reps and warranties. In every purchase agreement and many other material agreements, the parties make reps and warranties to each other. These are made at a specific point in time. Obviously, at signing, in a deal where there's a signing and a subsequent closing, they are traditionally remade at closing for purposes of the closing conditions. Parties will negotiate materiality qualifiers and knowledge qualifiers, and as of the date hereof qualifiers, and certain other qualifiers that are intended to make the reps something that the party that is giving it, actually true and correct when made. The risk of making an untrue rep, besides just a breach and indemnity, would also be a potential fraud claim, which would bypass the negotiated limitations in indemnity set forth in the purchase agreement. In terms of when they're made, that they need to be true and correct at signing and at closing, traditionally subject to a bring down standard, which we will discuss, but in most deals at closing, reps and warranties are brought down to an MAE, or Material Adverse Effect Standard. Melissa's going to talk about that in detail, but one key kind of early takeaway is that MAE is a very high threshold, and therefore, if closing certainty is the name of the game for the parties, an MAE bring down standard, which is commonplace these days, ensures that even if there are relatively significant breaches, so to speak, or inaccuracies in the reps being brought down at closing, the transaction will still close. You'll just kick to the indemnity standard for post-closing recourse. In terms of also the why on reps and warranties, it should be known that reps are really focused on disclosure prompting. It's about the seller telling the buyer everything material about the business that the buyer has negotiated for, and the buyer understanding the business that it's buying. And to the extent the business differs from that, having recourse against the seller for that. And that recourse is called indemnification, which again, we'll talk about, but traditionally there are limitations on indemnity, which we'll get to in one of the future slides here, which those include thresholds, survival time limits, et cetera. And then, at the bottom of the slide, we have traditional types of reps and warranties. These are specific to the target business that are negotiated between the parties. The key takeaway here is that if the buyer does diligence on target business and basically is relying upon certain findings from its diligence, it should have a specific rep that backstops its diligence findings and then ensures the benefit of its bargain. Going to the next slide, purchase agreements and pre-closing covenants, which, as we've noted, is something that is relevant in a signing and subsequent closing transaction. The main point here is that the buyer wants to ensure that the business it's signing up to by its signing remains the same in terms of value and structure at closing when it goes to fund and close and become the owner of that business. And so the interim operating covenants effectively say between affirmative and negative covenants, meaning things that the seller has to do and things that the seller will not do without buyer's consent, that it will operate the business in the ordinary course, that it will maintain the value of customer relationships and the general goodwill, and that it will not do an enumerated list of certain extraordinary or non-ordinary course type things without going to the buyer and seeking consent. These are all negotiated. These are all deal specific. There are certain exceptions where the parties will schedule, known exclusions from these interim operating covenants. For example, the seller might need to conduct an internal reorganization, move the target assets into a new company before the sale. Generally, that reorg would be spelled out on an exhibit and would be excluded from the interim operating covenant such that it does not require the consent of the buyer. There would be other exclusions for things that the seller knows that it will need to do between signing and closing. Perhaps they know that that is the time of year when they will be giving out equity incentives to management or increasing compensation for certain employees or things like that. But those are all potential negotiated exceptions to the rule. The other pre-closing covenant worth calling out, a couple of them. First, the effort standard for the parties to seek third-party consents and government approvals. Certainly in a deal that requires HSR, a seller will often require the buyer to utilize reasonable best efforts, including committing to divest of assets or enter into government required consent decrees in order to close the deal. That's often negotiated if both parties are strategic and there's real risk of one of those downside scenarios happening. But usually that effort standard is highly negotiated if both parties are strategic. There's also the access covenant, which deals with the buyer's ability to go onto the sites, conduct activities, things like that. Certainly in energy deals, there's a requirement where the sellers say to the buyer, you can't do any invasive sampling because that could turn up an environmental risk or environmental issue that had we not gone and looked, we wouldn't know about. And usually that's just restricted. And then, exclusivity and no shop. In a private target deal, the buyer will have the benefit of specific performance and so could force the closing if all the conditions are satisfied. But usually a well-represented buyer will require a no shop anyway to ensure that the seller stops discussions with third parties and that they don't have an incentive to walk the deal and go with a separate buyer or just hold on to the asset. that will give the buyer a separate claim for damages in the event that provision is breached. So moving on, purchase agreement, conditions to closing. Again, this is most relevant in the signing and then closing. But the point here is that there are certain conditions that have to be satisfied in order for the parties to be required to close. There are certain conditions that are mutual, meaning both buyer and seller need these conditions to be satisfied or waived by the other party in order to close. There are certain ones that are specific to the buyer, certain ones that are specific to the seller. And then sometimes there are deal-specific negotiated conditions to closing, such as a really important third-party consent might be something that the buyer requires to come in. So just to go through these quickly, both parties will be required to have a bring down of the reps and warranties made by the other party, or put differently, a buyer will not be required to close unless the seller's reps and warranties are true and correct, except as would cause an MAE, a material adverse effect, and vice versa on the other side. The seller would not be required to close unless the buyer's reps are true and correct, except as would cause an MAE. Similarly, compliance with covenants. Buyer wouldn't be required to close unless the seller had complied in all material respects with its covenants in the agreement that were, by definition, pre-closing covenants, and vice versa, seller for the buyer. And then, if HSR is applicable, the HSR waiting period of 30 days needs to have expired. Side note, traditionally, people would seek early termination if they wanted to get HSR done before 30 days. That is currently not available from the FTC and DOJ, so parties are having to wait the full 30 days. Often, a well-represented buyer will have a separate no MAE, no material adverse effect closing condition. Sometimes parties just rely on the rep that gets at the same point, but it's not quite as strong. And then there will be certain closing deliverables that need to be delivered by each party, which is really pro forma in nature. Last call out here, years and years ago, pre-2008 financial crisis, in smaller deals and in larger deals, buyers would often have a financing out, where if they were utilizing any financing outside of equity, such as third-party debt, that they could basically back out of the deal if the debt was not available. There's multiple different formulations of what financing contingencies look like these days, but the concept of a full closing condition relating to the buyer's ability to obtain financing is 100% off market. You just don't see it these days. So thought that was a worthwhile call out, and that remains the same through the current COVID cycle. So we're almost done here. We got 2 more slides before we kick it over to COVID developments. Indemnification. So the whole point of indemnification is it is a contractual remedy set out in the purchase agreement, negotiated between buyer and seller, that deals with the party's remedies for a breach by the other party of their covenants and their reps and warranties. And so usually on the rep side, there will be a specifically negotiated survival period where the reps survive for, if it's operational or non-fundamental in nature, call it 12 to 18 months, generally intended to get you past the audit cycle. Or if it's on the fundamental side, dealing with things that really should be 100% true, such as you own all the equity you purport to sell, you're authorized to enter into the deal is enforceable, things like that. It's often indefinite or a specific time period that is very long, 3 to 5 years, 6 years, something like that. That has been coming in a little bit of late, but in any event, it's still a long period. And then for the reps, there will be negotiated limitations between the parties, but there will often be a mini basket or a de minimis threshold for anything under a small amount, maybe $50,000 or $100,000 if it's a $100 to $200 million deal. Would not even constitute a claim that is indemnifiable. And then there would be a deductible, generally, where the buyer would not have any recourse against the seller unless all of the losses from the breaches for the reps exceed in total that deductible, often 1%, but it could be as high as 2 or 3%. And then finally, there would be a cap, which would basically limit the buyer's ability to seek recourse from the seller for all losses as a result of reps, sometimes covenants as well, above some total amount. Often that will be 10 to 15% of the purchase price. It is negotiated. There's different market terms depending on the various circumstances at issue. In some cases, the cap can be the entire purchase price. In some cases, the cap can be specific for each type of indemnity. In terms of covenants, usually those limitations don't apply. There's always a negotiated question around whether interim operating covenants should survive closing, and if so, for how long, or whether those should terminate at closing, such that the buyer cannot bring a claim after closing for a breach of a pre-closing covenant. And there's various other points that get negotiated here. Well, one other call out, which is related to rep and warranty insurance as well, is the materiality scrape. The materiality scrape is something that says that although there is materiality written into the reps and warranties in the purchase agreement, there is a provision which basically says that materiality is going to be disregarded for purposes of determining either whether there has been a breach or whether whether you're calculating or how you were calculating the loss. And so there could be a single scrape or a double scrape. Generally, it's a double scrape if you get one. But the point being, if you're going to have materiality in the reps, most buyers will negotiate for a scrape, which gets them the full benefit of the reps as though they were flat. And then usually the trade-off is the mini basket or de minimis, which goes hand in hand with not having any materiality on those reps. Last slide here, reps and warranties, insurance. So this is something that has become the norm over the past few years, including during COVID. This is where the buyer traditionally will get a buyer side policy. They will go through Aon or Marsh or another well-respected broker like that. They will get quotes from various insurers that are willing to quote their deal. And the insurer will basically act as the party that gives recourse to the buyer in the event that there's a breach of reps and warranties. The cost of that is generally 3 to 4% of the policy limit. If you assume the policy limit is 10%, which is like the cap in a traditional deal without insurance, then you can think of the cost as being 0.3 to 0.4% of the total deal value. Generally, insurers will insure any sector, but there are certain sectors that they are less interested in, such as Medicaid industry and the mortgage industry and certain pharma and insurance industries. A key call out here that Melissa will call out in more detail, but in competitive processes, buyers are often required to offer up rep and warranty insurance in order to be competitive. And usually a well-represented seller in an auction scenario will require buyers that want to be qualified bidders to utilize rep and warranty insurance. And this can be split between a no seller indemnity deal or a limited seller indemnity deal. The no seller indemnity deal means that all reps and warranties die at closing, terminate at closing, and there is no recourse for a breach rep post-closing, except for true fraud. A limited seller indemnity deal means that there's some negotiated exceptions, perhaps for fundamental reps or even for non-fundamental reps, up to potentially 0.5% of the deal value. Insurance basically has created a market now where it replaces in many ways the old seller indemnity that was negotiated. Usually there's a deductible called a retention in insurance speak, which is equal to 1%, which steps down under insurance terms to 0.5% after 12 months. And then you'll have that cap that you basically negotiate and pay for with the insurer, but usually 10% of deal value. The only issue with insurance, which parties continue to work out ways around, is there are exclusions, just like in any insurance policy, where the insurer will not pay the buyer, the insured, for breaches of reps where the buyer had actual knowledge of that breach prior to signing and binding that insurance. That makes sense, right? That would create moral hazard if it were any other way. But that also creates an issue where the parties become aware of a breach of a rep between signing and closing, because that will become de facto excluded as of closing. And so, without getting into too much detail here, there are different ways that parties negotiate to allocate that risk between each other. So I'm going to move on here to how COVID impacted purchase agreements and hand it over to my partner, Melissa. But that concludes kind of our general overview of PSAs. Melissa?
Thanks, Kevin. So now we're going to circle back to the various portions of the purchase agreement and talk about how COVID has impacted these. In a lot of ways, COVID has impacted nearly every portion of a purchase agreement one way or the other, regardless of whether a transaction is structured as a simultaneous sign and close or it's a bifurcated transaction. The first place that we go to is the purchase price. As Kevin mentioned, no matter what side of the deal you're on, value leakage and value certainty are key components to both sides. COVID has kind of forced us to reevaluate where are leakage points that were not otherwise there. And two big areas are, basically working capital. As Kevin mentioned, it needs to be normalized. And what that means is typically outside of tech, which tech a lot of times is high growth, so maybe a shorter period or looking at it a little bit differently. But in most industries, it's a 12-month working capital cycle, rolling 12 months. So you kind of get some cyclicality in there, some seasonality, and it's normalized. Well, what does that mean with COVID? What that means is that during the last 18 months, we've had actions that are kind of extraordinary that are reflected on the financial statements, including in working capital. So your receivables may be extended. You may have additional reserves for uncollectability. You may also have stretched out payables. You may have one-time severance payments. As part of the accounting process, and on the legal side, you should be asking these questions as well if you're accountants, is taking a look at the financial statements and saying, what should go in the target? Because if you don't put the appropriate components in the target, as a buyer, you're potentially leaving money on the table and having leakage. You're going to overpay effectively if you're not taking out these one-time occurrences or factoring in what would be normal. You need to scrutinize whether what they've done is in accordance with GAAP. Another component is indebtedness. The CARES Act has allowed payroll tax deferrals. So what that means is that the seller has effectively received the benefit of, service by its employees, but it's been able to defer the tax payment. Typically what we're seeing is this is accounted for one way or the other. It's either indebtedness or it's a transaction expense. The idea is that you shouldn't be paying as a buyer for these taxes dollar for dollar. This should be on the seller. While you pay it at a later point in time, it's not something that went into your transaction value. Another component that Kevin mentioned previously that we're seeing more common, again, more saw it in the tech space pre-COVID, but earnouts. So earnouts is a good way, it's a Band-Aid if you think about it, for a differentiation on valuation. A buyer may say, I think right now, based on COVID, there's some uncertainties. We can't tie out the projections. We need to think about what makes sense. We see reality being this for recovery, whereas, seller, you're a little bullish, you're seeing this. And so a lot of times what we're seeing now is earnouts in industries that we never saw before. People are getting creative, whether it's solving for the rest of 2020 and or 2021 rather, and then even 2022 with a lot of uncertainty. I think people are a little hesitant on sometimes valuation for, as our multiples start going up to back up to 18 and 20 times like we're seeing, people are also wanting to make sure that they're thinking about, does an earnout make sense in certain situations? So the next area of the purchase agreement that was obviously impacted is your reps and your warranties. As Kevin mentioned, the reps and the warranties in a transaction serve a couple of purposes. It's diligence, it's indemnification, or with the clean walk transaction, it's rep and warranty insurance recovery. As we'll discuss a little bit later on, rep and warranty insurance policies are generally excluding the impacts of COVID-19 on the company from coverage. So what that means is, even with your benefit reps or with your compliance with law, impacts that may have occurred on the business that relate to that specific topic, if there's going to be losses down the road related to it, the policy is not going to cover you. So from that perspective, it's really important that a buyer digs in and does more diligence that is specific to COVID-19, thinking about things, for instance, with the suppliers. Have you had supply chain interruptions? Have you had any suppliers that have gone bankrupt? Have you had any parts that you are unable to obtain? So warranty work, recalls, etc. Are you having issues? Are you having to do force majeure provisions in your contracts? You need to diligence these aspects. And as Kevin pointed out, your diligence should tie back to your reps. So while you will always have a general compliance with law, you may have a general material contract schedule that has different things that says, these are all the contracts, there's been no breaches, there's been no defaults, or a supplier and customer rep that says nobody has terminated, nobody's been late. These reps are becoming more expansive so that they're tying out to diligence. And this is to help basically a buyer determine risk allocation. If I can't receive it under an insurance policy, do I need to think about a specific indemnity for these matters that I'm not going to get coverage? And really, it's going to be on a case-by-case basis. It's going to be driven by an auction versus a proprietary process. It's going to be driven based on industry. We've had industries that have been harder hit by COVID, and others where it was a blip on the radar when it first happened. And maybe there's still some struggles because of either some customers filing for bankruptcy, slower supply chains. But generally speaking, some of them are regaining some normalcy. And so it's helpful to quantify and understand. And as we'll come back to insurance, this will also help you fight getting that COVID exclusion either very narrowly tailored, or in some instances, maybe removed because you're able to prove we're 18 months past it. This is what the company's done. And it shouldn't be applicable. There's not risk that the insurance is taking on anymore as a result. So the next part of the purchase agreement has been one of the most, I guess, scrutinized areas of a purchase agreement. It's the interim operating covenants. The interim operating covenants was intensely reviewed during COVID and was quite frankly a breach or an alleged breach of this provision was what a lot of buyers were claiming in order to get out of transactions when the market first crashed and we started the pandemic back in March of 2020. As Kevin mentioned, this covenant basically, it requires two things. First, the target's required to operate the business in the ordinary course between signing and closing. Generally, it's required to preserve intact the business, the assets, and the key relationships. And then second, there's this litany of items like Kevin mentioned that's highly negotiated, but it's actions that a target is not allowed to take unless they get the consent of the buyer. These are actions like layoffs, triggering warrant acts, issuing equity, taking on debt. So this covenant's intended to preserve the value of the business and ensure that it's delivered in the same financial state as the company was at the time that they signed. When COVID first was hitting, buyers, as I mentioned, we're looking at ways to terminate. And this was the provision that a lot of people turned to. A lot of people were saying, the actions that you took in response to COVID-19, those materially violated the ordinary course operating covenants. You departed from the company's operating procedures and patterns. Others argued that certain actions in response to the pandemic, including reductions in personnel, those resulted in economic deterioration of the company that was also in contravention of the ordinary course covenant. So Delaware courts spent a lot of time in the last 18 months digesting what does ordinary course mean? What is consistent with past practice? A lot of people were concerned with this because if you take a step back, you say, okay, what is the next COVID event? How do we need to think about this for the next purchase agreement? How do we need to address it for the next emergency? And so Delaware has spent some time looking at this. And what they have found is that, in many sophisticated transactions where a seller has sophisticated counsel, that counsel is requiring that the covenant to operate in the ordinary course of business is further qualified by using a commercially reasonable efforts in connection with the operations. Delaware courts have found that there is no implied efforts qualifier on the ordinary course covenants, emphasizing the importance of negotiating this in if you're a seller. So if it's read flat, it is flat, and the courts are going to scrutinize your events, your actions, or inactions with far higher scrutiny than they would if you had a commercially reasonable efforts qualifier. Basically what Delaware has said is that if you have this qualifier, what they're going to look at to see if you were in material compliance with this covenant and if there's a termination right, they're going to look at similarly situated companies and see what have they done, see if the actions or inactions by a target are reasonable, and account for the fact that a party's ability to perform its obligations, quite frankly, may be hindered by events outside of their control. For instance, we've had some of these local laws that have required, quarantining or factories being shut down because there's been too many outbreaks, or stay-at-home orders. As COVID-19 has developed, we've now regularly seen sellers, including general kind of broad exceptions to interim operating covenants that we weren't seeing back in March. Now, almost every purchase agreement you pick up is going to have an exception that says, we don't have to come to you, buyer, and we don't have to act in the ordinary course if we're responding to COVID-19. You have to take that and think about it from the other side of it. So from a buyer's perspective, you appreciate that the seller needs to do what it needs to do. It needs to respond to a public health crisis. But at the same time, the buyers also have an interest in preserving value. and may want to consider consent. And what we've been seeing a lot lately is buyers are going to get a consent right, a consultation right, a notice right that restricts certain events. If you go through that enumerated list of prohibitions, and we really think critically about what would deter from the value, what would deter from us going back to business as usual, what would have an impact? And a lot of those are related to workforce. That's issuing additional debt. That is making distributions out of assets. And you're going to say, okay, you can do what you need to in connection with COVID, but you can't with respect to these matters unless you come to us and we get a consultation right. We're also seeing buyers trying to limit, what they can or cannot do in terms of, obtaining benefits under the CARES Act. This isn't quite as much applicable right now as, the window for the PPP loans have closed and everything. But in summary, basically, a buyer needs to be very mindful to not just agree to just an ordinary, course carve out for COVID-19. If you do so, a buyer that's not paying attention or their counsel's not paying attention, you potentially gut the entire interim covenants and could wind up with a surprise when you show up on closing date and not really actually have a right of recourse. You won't have a right to claim a breach if you've potentially undermined the overall covenants, which is what we're seeing buyers, quite frankly, do in the initial auction drafts. You also need to be mindful of balancing the buyers and the seller's interests. And very important for strategics is to make sure you're not violating gun jumping. That again goes to a balance of making sure the interests are aligned. The next area I'm going to quickly touch on these points is other pre-closing covenants. So COVID has impacted accessibility to properties. So you need to consider, how accessible the property is, if you shouldn't allow access for diligence between signing and closing, unless it's in compliance with public health measures. Sellers are going to have to help with financing cooperation. They may want to ensure that a failure to be able to deliver a solvency certificate is not a breach of that covenant, and that a buyer cannot terminate the agreement for it. It may be outside of their control, especially when we've got these distress situations. We still are seeing distress transactions. That's maybe something that they cannot meet, and they don't want the buyer to be able to get out of the transaction. Quickly on regulatory approvals, as Kevin mentioned, we're having a lot of delays still. The DOJ and FTC have come out and said, we're still not going to do early termination. We also have been seeing people flip back to what was happening when, there was furloughs and the government was shutting down and putting automatic extensions into HSR, or failure to get HSR with respect to an end date. So if there was a government shutdown, DOJ was not open, the outside date gets extended for that time period for an automatic period, plus maybe a little buffer to allow some time. The government, no different than every other business, is just understaffed right now, and it's creating a lot of delays, especially in foreign jurisdictions. The last part that I really want to touch on is MAE. Outside of the interim operating covenants, MAE has become the most focused on provision with COVID. And if you think about timing, we had a lot of transaction agreements that were executed prior to the pandemic hitting. At that point in time, we hadn't really had something like this other than the financial crisis that people had really been thoughtful about on when an MAE could occur and when it couldn't occur. And so two ordinary course ways that people try to terminate are MAE and interim operating covenants. We saw a return of this, and Delaware courts, if nothing else, have held the line and shown us that an MAE is what they've always said. It's got to be durationally long and have a significant impact on the business. Basically, a reduction from earnings projections, et cetera. It's not just down 10%, it's down 90%. It doesn't make sense anymore. And so the MAE has come under a lot of scrutiny and with COVID. The first part relates to facts, circumstances that have a negative impact on the business, financial and operating condition of the target, or its capacity or ability to comply with the obligations under the agreement. The next part of the MAE definition that you see is basically the exceptions. When does an MAE not exist? These are always things that are outside of a seller's control. It's general market conditions, it's changes to law. And quite frankly, even pre-pandemic, we were seeing pandemics, epidemics, public health crises. This is standard now in agreement, including express carve-outs for COVID-19. That said, what's become the most critical part that everybody's scrutinizing is the disproportion and effect language. So your control group. So while you have exceptions to what an MAE is, you have an exception to an exception. And basically you can look at the impact of these out of your control items like COVID-19 and said, has it had a disproportionate effect on the company as compared to a control group? The control group has become a very intensely negotiated provision. What is that control group? Is it just the industry and the region that the seller operates in? Does it include the operations of its subsidiaries? As a seller, you want this control group to be very narrowly tailored, as it really helps kind of scope your liability and ensure that you've got closing certainty, that a buyer can't claim an MAE. On the flip side of that coin, as a buyer, you obviously want a very broad control group. And then the last thing that we'll quickly, I'm conscious that we're running out of time, we have one more slide, is rep and warranty insurance. And as Kevin mentioned, the market is as hot as ever. In fact, insurance companies are not able to keep up with demand at this point, and we're seeing on some transactions, people aren't even able to get a bid, any quotes. Other instances, I'm in auction right now where we got one quote. One quote's all we need, but you know, things have changed. And I think a very important takeaway from this is insurers are going to focus on the impacts of COVID. So you better have done your diligence to see what the impacts were and how the companies mitigated it. So with just a couple minutes left, we're going to turn back to where we are now. And I think the first point is basically M&A is back. M&A is back to pre-COVID levels. Seller is very much getting a seller transaction deals. In fact, we're seeing for deal certainty, because that's been the concern with COVID, we're seeing full equity backstops by our private equity clients. So they're in the same position in a competitive auction as a strategic who doesn't have a specific performance right or a financing out condition or termination right rather. We're also seeing termination fees go up drastically. Pre-COVID, you know, the average range was 4 to 7. We're seeing people go up to 10% to provide buyers that comfort that if it's not a full equity backstop, there's at least going to be a higher threshold. You know, in competitive auctions, you know, we're also seeing, as we mentioned earlier, a lot of earnouts and valuations. And still rep and warranty, clean walk transaction are still going to be the driving force of what's going on. You know, 65% of transactions of full spectrum from small deals to large deals of what we've seen over the last 18-month period have all included rep and warranty insurance and provided a clean walk to people. Kevin, do you want to talk about any of the rest of these points? Turn it over to you.
Yeah, sure. I'll touch on the second point, and then we can wrap it up. But yeah, the second point I think is kind of intuitive. Get my video on here. So the second point I think is intuitive insofar as we've been in COVID now. You know, notwithstanding there's various variants that coming and going for the better part of 18 months, and so all of the points that Melissa went through in terms of buyers putting pressure on assorted breaches of interim operating covenants, you know, claiming an MAE in order to renegotiate the deal, maybe change value, maybe walk away unscathed. You know, that's all sort of come full circle. And then in terms of what outside lawyers on both sides representing buyers and sellers are negotiating, that there's a pretty well-worn path at this point as to what you know, is acceptable in terms of allocating risk for COVID. If anything now, you know, we're looking at parties negotiating things that are sort of the flip side of COVID, but it's really the return to work and what sort of non-ordinary course things are coming up as a result of that. Melissa, I'd actually hand it back over to you for the final couple points here, if you want to touch on anything.
Sure. So I think with respect to rep and warranty insurance, the market is very well developed on what exclusions will be there for COVID. A lot of the insurers have a very standard exclusion. I will have to say, I know it's a plug, but Kirkland does more rep and warranty deals than anybody in the country. And we have standardized forms with every insurer. And based on the diligence and the our relationship with the parties, we've, in many instances, I just did one where we got the COVID exclusion entirely removed. And another transaction, it was scoped so narrowly that we felt very comfortable, even though it was actually an app-based company that dealt with driver performance for delivery services. So there were some impacts with COVID on that business, but we were able to not have a very, very narrowly tailored scope. So I do think it's important when thinking about that, making sure that you've got a good champion, a good supporter, and you've done the work on your end. We're starting to see some more normalcy with policies. And then, as I mentioned, I think the last takeaway is, even with COVID, there was one, maybe two MAEs that were found by Delaware courts. Delaware courts are consistent, if nothing else. It has to be durationally long. It has to have a significant economic impact. And MAE standard has not changed. And so, like I said, it's one of those things, if you weren't going to find it during COVID, financial crisis, we only had a couple since that time period. So I think it's very clear that it is still the highest threshold that you're going to have for trying to prove the right to terminate.
Thanks for joining us.
Appreciate your time. And if you have any questions, please feel free to reach out or even additional market information. I know we had to rush through those last things. We're happy to talk to you about where we're seeing the market at right now and what we're seeing on deal terms, whether it's just strategic, proprietary type of deal, or if it's an auction process.